As I say, good morning. Welcome to the King's Chambers webinar on the Planning and Infrastructure Bill. My name is John Hunter. I'm a barrister at King's Chambers. I'll be chairing the discussion today, and you'll be hearing from my colleagues who I think you should be able to see, Aravik Jackson, Killian Garvey, Stephanie Hall and Stanzi Bell. They're going to be dealing with the detailed topics. I assume by now you're familiar, perhaps at least with the broad outline of the bill. It is, I think, fair to say, one which proposes a series of quite fundamental reforms in the planning and related systems, and it has a very wide sweep, ranging from provisions for streamlining and speeding up the consenting process for nationally significant infrastructure projects, the establishment of a new system for environmental delivery plans, and a nature restoration fund in order to deal with things like, I suspect, nutrient neutrality problems that have risen in connection with protected sites and protected species. There's a whole new system, or rather expanded system, of sub-regional spatial development strategies based on the London model, which you're going to hear more about. And then there's the devolution of powers to local planning authorities to set planning fees, and by contrast, the more prescriptive provisions we're going to hear about on delegation or national scheme of delegation for the exercise of planning functions and planning committee reforms. And then there's a whole variety of other measures many of them of quite substantial significance, including changes and bringing updates to the CPO system and the basis on which compensation is assessed. For obvious reasons, in the hour that we have, we're not going to be able to cover all of that. But we've decided to focus on a number of key issues that we think are particularly important and of interest to those working in planning, be that local authorities or developers or other interest groups. They are, if I go through them, firstly, planning fees reforms. Secondly, the reforms relating to the National Scheme of Delegation and Planning Committee reforms, strategic planning reforms, and the NSIP reforms that I referred to at the start. In terms of procedure, this webinar is recorded, and nobody, I think, apart from the panelists, will be appearing or be able to speak in the audio, but there is a question and answer panel or function that you should be able to have access to. It's not clear whether or not we will have much time to deal with that at the end. So what we're proposing is that questions should be put using that function. If we have time at the end, we'll do our best to go through those, but we'll deal with it that way rather than after each topic. So in terms of slides as well, I've been told that slides will be sent out automatically to you. If that doesn't happen, please feel free to email and request them. So without further ado, I'd like to introduce the first speaker we have, which is Aravik Jackson, who she's going to be dealing with the issue of planning fees reform. So if I could hand over to you, Aravik.
Good morning, everyone. So this is a run through Clause 44 of the bill. Clause 44, fees for planning applications, etc., introduces a new power for the Secretary of State to subdelegate the setting of the planning fees to local planning authorities. Now, this power comes in the context where fees are currently set nationally, and there's been an issue for a while and calls for ensuring that planning fees, in fact, do cover the costs to the local authorities of processing and determining planning applications. An alternative would have been to increase fees nationally, but there is some disparity as between different authorities as to what the cost actually is. And this power seeks to remedy that. So on one hand, this power is introduced allowing for better cost recovery and flexibility. And on the other hand, there are restrictions set and limits as to how this power can be exercised. And one of them is Clause 44.3, which introduces subsection 8b. So the fee must be calculated or set with a view to ensuring, so far as possible, it doesn't exceed the cost of carrying out the function in respect of which it is imposed. So the idea is not to bring additional income. The idea is to ensure cost recovery, hence the limitation. The limitation itself is quite flexible, so it does allow for flexibility within the provision. So it says so far as possible and to be set with a view to ensuring. Now, the next one, which I suppose can also be seen as a limitation or safeguard in terms of the power that's being granted, it's introduction of Section 8C. And the idea here is that the fee income is to be retained and not cross-subsidizing other services. So the idea is the reinvestment back into the planning process. The functions that are the functions for which the income can then be spent, those are also specified under subsection 8D. So what happens then if the authority sets the fees and exercises the power, and those fees are inappropriate or somehow unjustified? The bill proposes the introduction of additional section into the Town and Country Planning Act for directions in relation to fees set by the planning authorities. And this applies where the fee or charge is set and or is proposed to be set, and the Secretary of State considers it to be not at appropriate level, in which case the Secretary of State may direct the authority to review the level of the fee or charge. So this is a safeguard that allows for the intervention to make sure that the power is exercised for the purposes of the cost recovery. What happens if the fees remain inappropriate even after the review? The clause 44.6.3 provides a further safeguard in that respect. So, charging authority to which direction is given under subsection 2 must review the fee or charge and notify the Secretary of State of its decision as a result of the review given reasons. And then if it fails to do that, if there's a failure to review, if there's a failure to notify of the decision and provide reasons, then subsection 5 kicks in. Or if the authority does comply, but the Secretary of State still considers that the fee is not at an appropriate level, subsection 5 kicks in, which allows the Secretary of State a further power of intervention, whereby the Secretary of State may direct that the fee or charge is to be of such amount as may be specified or determined in accordance with the direction. And the final clause that I'm going to look at is 44.6.6. So this clause governs the position as to what happens in the interim, like in the meantime. So the Secretary of State may, by regulations, make provision about the time by which any requirement imposed by or under the section must be complied with, about the fee or charge that is to apply while a charging authority reviews a fee or charge, and about any repayment of the fee if the fee is then or charge is then reduced as a result of a direction. So overall, the idea is the introduction of this power that allows for better cost recovery and flexibility, and then there are safeguards introduced around it to limit its application and make sure that it's the idea of cost recovery that's furthered. Thank you for listening, and over to you, John.
Thank you very much, Eric. I see there's a number of questions. As I said before, I'll leave it till the end to answer those, but thank you for those. So the next topic is going to be the one of planning committee reform, which Stanzi is going to be presenting. Trust many of you have been familiar with Stanzi. I'm not going to spend a long time on introduction. Very experienced and excellent barrister. No doubt you'll know if you've encountered her before. So Stanzi, if you could take it away, please, on committee reform.
Thank you very much, John, for the introduction, and great to be joining everyone this morning for this important topic. So my discrete issue is planning committee reform. And I've got a few slides to run through on that topic, perhaps unsurprisingly. Fingers crossed the gremlins won't strike again. We'll have to see how we go. So in order to understand planning committee reform, the first thing we need to do is travel back in time and remember a working paper of December 2024. And what we will hopefully recall from that paper, or you might need a bit of a refresher, you find it all online if you're interested and you want to do a deep dive. But the headline points that came out of that paper were as follows. Firstly, the suggestion of a national scheme of delegation, which would be designed to facilitate faster delivery of the quality homes and places that our communities need by bringing greater standardisation over the operation of committees, in turn to give greater certainty to applicants. That was the first big idea. The second big idea was this idea of smaller targeted planning committees, specifically really for strategic development. And finally, a mandatory requirement for training for all planning committee members. And the paper identified really a lack of clarity about who will be taking decisions on applications, and the fact that too much time is spent on applications compliant with local plan policy, and a lack of transparency as to the consequences of committee decisions. So what is the problem that government is trying to address? Well, what they've told us is that the current system causes delay on decisions which relate to schemes that have already been considered through the local plans process. And we're told that this in turn delays good outcomes for places and communities, wasting the time of councillors and applicants. And I'm sure everyone who's joined us this morning will have experience of situations where there is an allocated site in a local plan. Perhaps there's been a requirement for a master plan under the relevant local policy. And then for a matter of years, that planning application really struggles to get through and get approved, such that there's a planning permission in place to bring forward that scheme. And it seems to be that sort of issue that is being tackled through this paper and these reforms, development supported by the local plan that is just struggling to get its way through the system. We're also told that a current problem is that the current approach to training is inconsistent. You may well be aware that there's no statutory requirement for training, and therefore there is an issue, we're told, with inconsistencies of knowledge relating to planning law and practice. Certainly it's my experience, and it may be that others wish to share their experience on the Q&A, but it's certainly my experience that all authorities will train members in some way or another, whether that's through the head of planning or the head of legal or through inviting in external speakers. Most authorities currently recognise the importance of training and do provide it, albeit that's not on a statutory footing. We're also told that there's a problem with a significant number of local planning authority decisions being overturned on appeal, and we're specifically advised that this is the case when those decisions depart from officers' advice. I'm sure plenty in the room will have experience of that issue as well. And we're then told that it's unusual for a regulatory function as complex of planning to not require core training. Again, circling back to this issue of lack of training, lack of knowledge. So what's the solution? Well, firstly, the national scheme of delegation. And what we're told there is that regulations will set out which functions will be delegated to planning officers, and which decisions will instead go to planning committee or subcommittee. So stay tuned to regulations in that respect. More specifically, we are told through the insertion of a new clause in identified to be dropped into the Town and Country Planning Act. We're getting these wonderful long names now for all the drop-ins. So we're looking at 319ZZB, just trips off the tongue. Requirement discharge of functions for local planning authorities. We've now got a drop-in of ZZC as well, a requirement for functions to be discharged by committee, subcommittee or officer. And what this basically says is there will be regulations which are going to set out in the detail of what is going to be discharged by whom and in what circumstances. And the regulations will prescribe the terms of those arrangements, but they will also confer a discretion on any person with the delegation of a function. So it won't be an absolute tramline approach. There'll be a discretionary element. And where those arrangements are in place, unsurprisingly, decisions should be exercised in accordance with those arrangements. So what this means in real terms is probably a lot more decisions for planning officers, The mood music seems to be, and we'll wait for the regulations to see the detail, but the mood music seems to be a move to possibly delegate decisions where it's clear that the planning application is on all fours with local policy, is identified in the local plan as an allocated site, etc., to move those sorts of decisions that sometimes get bogged down in local politics out of the hands of committees and into the hands of planning officers. I think one of the interesting ramifications of this is through a national scheme of delegation, it will be a lot clearer and a lot more transparent who is the ultimate decision maker on an application. But that may in turn create more pressure on officers because it will be much easier for both applicants, but also objectors to the scheme and disgruntled third parties to contact the officer in question with their thoughts and comments on any of the applications that they may wish to object to or be in support of. So you really are, I suppose, identifying a key person who will be the decision maker, and you're opening that person up to some real pressure. The government tells us through its guide, there's a helpful guide. Some of you may have seen it online. It's a sort of Q&A sort of approach. I'll identify some of the other points that are picked up there later in this presentation, but there's a sort of quite choppy guide that has come out with the bill. What's said through that is that this measure will ensure greater consistency and certainty about who in local planning authorities will be responsible for making decisions. What's the solution? What's the next solution that government has identified? Well, it's this issue they say about limiting the size of planning committees. That apparently is a specific problem that has been identified that we can solve. We can legislate to solve it. We'll do that, we're told, by dropping in 319ZZD, size and composition of committee discharging functions. And again, what that section will do is, through regulations, prescribe how committees are to be composed and the size of any relevant committees. So what we're also told through that through the bill is that if a committee or subcommittee discharging a relevant planning function fails to satisfy any of these requirements, that won't engage paragraph 43 of Schedule 12 of the Local Government Act of 1972, validity of proceedings. So circle back later to find out more about what that might mean in practice. But it seems that size of committees is a real issue that government says needs to be solved. We then turn to the issue of mandatory training. So mandatory training is going to be introduced. There's going to be a process whereby certifications are given to all planning committee members. Again, the relevant section here, another drop-in that trips off the tongue. We've got 319ZZA, and it relates not only to local planning authorities in England, but we've also got mayoral planning functions. And what we're told is going to be the case here is that a mandatory training scheme will be in place. You will need a certificate in order to sit on a planning committee, which will demonstrate you've done your training. And if you don't have your certificate, you shouldn't be on planning committee. There'll also be a sort of allowed provisions around record keeping. You'll also be required as an authority to display a list of your members who are currently certified online so that people can cross-check that they do indeed have the certification that they are supposed to have. We're told that this is important because it's necessary to make sure that there's an adequate level of understanding of planning law. We're told through the same guide that I identified earlier that a wide range of implementation options are being explored and that there'll be an opportunity to work with various stakeholders to look at those options in more detail. They note there are good examples of training across the country, but that this is inconsistent, and that they're keen to work with local planning authorities to find best practice. I remember at one point in my practice doing a lot of local authority planning committee member training. I think at one point I was going across country with Phil Robson to meet various members and do to deliver sort of standard training. I think for what it's worth, my favourite question that I ever had from a planning committee member was after a few slides on unlawful decisions, a question from a gentleman who put his hand up to ask, what if I want to make an unlawful decision? So query exactly what the content of this training will be. Doesn't seem at the moment there's any requirement to pass any test or anything like that at the end of the training. So it will simply be a case of demonstrating you have in fact done the relevant training. which I think leads me on very nicely to an observation that was made by Oscar Wilde that always makes me chuckle, who of course famously mentioned that the whole theory of modern education is radically unsound. Unfortunately, in England, at any rate, education produces no effect whatsoever. If it did, it would prove a serious danger to the upper classes and probably lead to acts of violence. Now, I can only imagine he would have revised his view if he had sat through the members' training that Phil Robson and I had so conscientiously prepared. But in any event, I think the takeaway here is a lot of stock is being placed on education. The idea is if we can bring members up to a certain standard level, quality of decision making will improve. There's an interesting selection of FAQs that are in that guide, and I'll see if I can post a link to the guide in the Q&A or in the chat in case anyone is interested and hasn't had a chance to see it. The FAQs, I think, are quite telling. Interestingly, they say things like, are these measures undermining local democracy? And we're told no, this is about streamlining and efficiency, retaining democratic oversight. And then again, I think this is key, this last bit of the FAQ, having a national scheme of delegation will improve the recognition of sites that already receive democratic approval through the local plan process. So remember what I said earlier about the mood music being, we need to take away these allocated sites that are already approved through local plan. We need to get them out the hands of members and back into offices because of delay through the planning system. Next question is identified in the FAQs under this bit is, will these measures remove the voice of local communities? We're told no, perhaps unsurprisingly, but we're also told that the best way for councillors and communities to engage in development proposed for their areas is through the local plan process. So pushing local plan process as the arena for engagement. And then again, we're told we think that where controversial development is proposed that has not been planned for, councillors play a key role in representing the voice of their communities. So there's the suggestion here that really the function of planning committees in the future will be to deal with unplanned for development, not development that's been identified through the local plan process. And there's a note that we're not changing any of the consultation rules on planning applications. So consultation will remain. And are you taking away planning decisions from councillors because they are unfit to make them? I mean, wow, what an FAQ to drop in the guide section. That is quite on the nose, isn't it? But no, what we're told here is a national scheme of delegation will create certainty. Councillors will have had an instrumental role in the development of local plans, and we think that the planning process will be expedited for proposals that meet the objectives of the plan. We think that controversial development proposed that hasn't been planned for is where councillors need to play their role. But wow, what an on-the-nose question for an FAQ. That's pretty bold stuff. So that's my whistle-stop tour of the proposed planning reforms. I've seen the Q&A flash away, so doubtless we'll be able to pick up some of these themes later if there's time. I think our learned chair has indicated we're doing questions at the end, but I couldn't resist sharing my favourite slide and encouraging you to post your questions or your observations. Thank you very much. Thank you, John.
Well, in the best tradition of the bar, I've decided to change my argument on my feet. And I think given the number of questions, what I'm going to do is, I think it's evident already these two topics are of great interest in practical terms to a lot of people. And there's no way that we're going to have time to go through all the questions. But I thought it might be helpful, given I think this is a natural break. The next two topics, these are two related topics. The next two aren't. So I just might take a few of them and then we'll come back to them at the end. So if I can, Aravik, by all means chip in and same Stanzi. I was just going back to the first in them. Loads of questions about planning fees. I think lots of them to do with where the money will go and whether or not the first one is whether or not all the fee is ring fenced to the planning service or just the increase. My reading of the bill is that it's all of it. It's not just limited to the increase, although obviously there's going to be regulations which can make detailed provision. So it's possible that might not prove to be the case. But on the plain reading of the bill, it seems to me that there's also questions about whether it will lead to increases. Well, I think it plainly is recognised that's really what it's intended to do. So yes, it will create power for an increase. It's unlikely. I would have thought the planning authorities will be Turkey's voting for Christmas and reducing their fees. And there's questions about what happens. Lots of questions about the amount of work that's involved and so on, and whether or not the authorities can decide not to do it. Well, I think from the guidance that I've seen, it's suggesting that there will be a national default. So presumably the intention is that it won't be, the authorities can simply follow the national default or seek to justify their own fees. I don't know if anyone else has got a different view on that. The only other question I'm going to answer now again, because I'm sorry, these are the ones at the start. So if you're further down the list, it's just not been possible to go all through them yet. One question is about whether fees go to enforcement. Again, on my reading of the bill, there are a list of specified functions which the fees can go towards. And in relation to enforcement in Part 7 of the 1990 Act, it is the only functions that are referred to are the functions of dealing with certificate applications, interestingly. So it's not clear to me that it can be applied generally to the whole enforcement service. But again, the devil may be in the detail of the regulations. That's fees. I probably haven't got on to committee reforms. And let me have a quick look of those.
I saw an interesting one.
Don't you have any that you want to answer, Stanza? You go.
There was one that was interesting about who will provide the training, the new mandatory training. At the moment, it's not clear. There's no clarity around will it be an internal process or an external process. There will, however, be a process of certification. So you will need to have your members have a certificate to say they've done it. So it may be that you end up with a system where there are multiple providers, all of who've been endorsed by government. But if you're trained by a process other than by one that would give you that certificate that's been recognised, it won't be up to snuff. So wait and see, I think, is the answer there. And I can see also people have made reference in the comments to how they train their members and arrangements they currently have in place. So it seems that that's something that's already ongoing and in the experience of those who've joined our webinar this morning.
I think one of the interesting things for me that I noticed was after all this stuff about having to have the training and be accredited and so on that you've gone through, there's then annoyingly for the lawyers a provision which says that this can't affect the validity of any decision. So I was hoping that would provide some new legal grounds for challenge, but they seem to be heading that one off at the pass.
Absolutely, yeah, you're quite right, John. So that won't unfortunately be a basis of challenge that one of the committee members' certification had lapsed by 2 days or whatever.
Yeah, and I think so. I think Emma Cole from Stockport pointed out it feels like the planning advisory service will take the lead on training. Well, that sounds awfully sensible, and one hopes that will be done. But again, I think the bill is skeletal in the sense that, as usual, lots of these things are kicked into the long grass for regulations to make detailed provision. So, right. Obviously, the bill only came out just over a week ago. It's about to have its second reading. A lot can change. It seems to me perfectly plain just from the volume of questions on this that this is going to generate a lot of responses and presumably input from both the Commons and the Lords on this. So it may be that the final bill responds to a number of the questions and concerns that have been raised, or that it's punted off into regulations. I don't know.
I think someone has also raised the question of committee size, asking if setting sizes are being set at this moment, and it's the point you just made, John. That is an issue that's being kicked down to regulations. So we will wait for regs to set the sizes of the various committees, but certainly the mood music is they want smaller committees rather than larger, and then we'll see what that means in practice.
Right, I'm going to cut it off there because we're past the half-hour mark, so I'm conscious I don't want to run out of time, and some people I know have already had to leave, so I don't want to anyone else to miss the main topic. So we'll go next then, if I may, to Killian. Should be familiar to many of you. He is, despite his fresh face, an old hand at delivering these webinars, so I have high hopes for what we're about to hear next. And again, without more ado, Killian, if you could take over from me and speak on the topic of spatial development strategies. Thank you very much.
Thank you very much, John. Good morning, all. Good to see you all. So we have a new acronym to learn. As you'll know, we love acronyms in the planning industry, and the new acronym to learn is SDS, which stands for Spatial Development Strategies. And if this bill is to become law and the changes are to be introduced, I envisage that we're all going to become very familiar with this acronym, because what this is a change to the way in which development plan policies are going to be approached. And the way I perceive this is I think we're going to have a new tiered approach to development plans, essentially. As you'll know, for the most part, what we do now is we look at the development plan of a local authority. This is outside of London. We look at development plan of a local authority. we might look at a relevant neighbourhood plan, and then we sort of slot in the MPPF and PPG. But it's predominantly local plans and potentially neighbourhood plans that we will look at. But the SDS brings in a different tiers, because I think what we will be moving to a world of is we will have national development management policies, which will be you might have a generic landscape policy. It should not adversely affect the landscape, or heritage policies. We'll then have sort of what sits beneath them, spatial development strategies, these SDSs, which will almost be like your Part 1 local plans, almost be like that. We'll then have local plans, so local authority specific plans, which will be beneath that. And they will be almost like your Part 2 local plans, which will have your allocations, and then you'll have neighbourhood plans under them. So we're going to have this sort of tiered approach to development plans, and SDSs will fit within them. What SDSs will contain, we don't have a huge amount of information on, but there's certain clauses in the bill which I think are quite telling. So if I share my screen, and hopefully, folks, you can see this, it tells us here what the contents of an SDS are, that it can contain a statement of the Strategic Authority's policies in relation to development and use of land in the strategy area, which are of strategic importance to that area. That's so generic, it's unclear really what that says. It's essentially, you can have policies, but here's some important caveats to that. A spatial development strategy may specify or describe an amount or distribution of housing of any kind, an amount or distribution of affordable housing or any other kind of housing. That's why I'm saying they might read a little bit like your Part 1 local plan, because which might set out a strategy, or a distribution of housing, and critically may describe it may be strategic importance to a strategy area, even if it affects only part of that area. A spatial development strategy may make different provision for different cases or for different parts of the strategy area, because these SDSs will combine different local authorities and look at providing sort of a development plan structure that might combine a few small authorities or one larger unitary authority. And it could say this area is going to take this amount of housing, this area is going to take that amount of housing. And then critically, it says a spatial development strategy must not, and these B and C are quite important, to specify particular sites where development should take place. And again, that's why I said it might read a little bit like a Part 1 local plan, because it's not going to have any allocations. Indeed, SDSs can't have that, because that would be a specifying a particular site. So that's where your local plans will come in with your allocations. And that's why I'm trying to use this analogy of a Part 1 and Part 2 local plan, because I think that's probably the closest what we can envisage what this might look like, where your Part 1 is setting out, this is how much housing you can have in these sorts of areas, and then your local plan will come forward, and that might say, and here's the allocations to meet that. And then being consistent with or repeat any national development management policy, which is why I'm saying if your national development management policy for, say, landscape or heritage or biodiversity net gain, you wouldn't be needing to repeat that in your SDS. In fact, you can't do so, which is why your SDS might be relatively brief, but of huge importance if it's going to be setting out what the housing requirements and distribution of that housing will be. Okay, so turning to how the government have described SDSs, they say with the exception of London, most of England is not currently covered by strategic plan, and there's an idea for anyone who doesn't work in London, these sorts of spatial development strategy, these sorts of larger local plans are common in London, and where you've got the London plan, and then each individual authority within London has its own local plan that sits beneath that. It's trying to take that idea and spread it nationally. It's clear that housing need in England cannot be met without planning for growth on a larger than local scale. So housing is what's driving this SDS. And there is some discussion about infrastructure, but it's very clear from the tenure of the clauses, SDSs are housing. They don't talk about employment or otherwise. It's housing. That's what these are geared towards. And you can see it's closely modelled on a system that's been in place in London for over 20 years. And what the idea is, a duty on combined authorities, combined county authorities, upper tier county councils and unit authorities to prepare an SDS for their area. And also enables the government to establish what's called strategic planning boards to prepare SDSs on behalf of specified groups on these authorities. So looking at the questions that they sort of asked themselves, I'm a bit like Stanzi, it's quite telling the questions that they've decided to put up. Are you reintroducing regional planning? No. Regional planning was larger areas than are being envisaged by SDSs. What will they contain? And it's a little bit nebulous, this answer. Play a vital role in delivering sustainable growth. In terms of what it will contain, I think it's those clauses I took you to a moment ago. They will talk about distribution. They won't contain specific allocations. And is it going to take a decision away from local areas? Isn't it opposite to devolution? And it's making decisions at the appropriate level. I mean, it does, in a sense, take decision-taking away from a entirely local area, because it will be the SDS will say, this is how much housing you need to be planning for. Now, the local area, the local authority can still come forward and discuss the distribution where the allocations should go, albeit if the distribution of housing is set by the SDS, it might be to the effect that the SDS says you should have, for argument's sake, 30,000 homes over the planned period, and you should focus it on the larger settlements. So therefore, you should be aiming to have 8,000 in this settlement, 5,000 in this settlement, 3,000 in smaller villages. That sort of strategic settlement strategy. And the local plan could come in and try and find the sites to actually meet those numbers. But they've, in some respects, they've been told this is the way you should do it. And that's my guess as to how SDSs might play out. And then in terms of the rest of the clauses that we see, there's an awful lot of clauses that relate to this. And I'm going to sort of cut through a lot of them, because a lot of them, there's an awful lot there, but a lot of them are actually quite straightforward. It's sort of just setting out, this is how they're going to be working. So it tells us the sort of areas that we're envisaging. And then it's sort of, we can set up strategic planning boards, which is essentially the Secretary of State can set up strategic planning boards. And that strategic planning board will, for argument's sake, will be sort of the council, the authority who are advancing an SDS. Now, a lot of what else we see won't come as a huge surprise. A lot of it will be very familiar, because it will just be like another development plan. And if we were to go through the provisions, you'd see there's an awful lot there just about how the Secretary of State can interfere, how the Secretary of State can set timescales. You'll see. So, yeah, the timetable, again, that the Secretary of State may direct what's going to do it, what the timetable is, but you need to have a timetable. So again, a lot of you might be thinking, well, this just feels like a development plan. And indeed, there's provisions relating to how you prepare it, which none of you will, if we were to go through, none of you would think, oh, well, that seems unfamiliar to me. A lot of you will just be thinking, well, this just feels like how a development plan is prepared. It's just a development plan for a different area that doesn't contain any allocations. Again, consultation, very much familiar to you in the way in which one goes through the consultation, going through an examination, and indeed the actual examination. You'll have a public examination, which will be held by someone appointed by the Secretary of State. Again, it will just be another development plan for all of our purposes, but it will be promoted by the Strategic Planning Board, and it will feel just like an examination, but there'll be a number of authorities who might be warring amongst themselves. Who knows? We might have some fun in that respect. But a lot of this will feel very familiar to an awful lot of you. And there's lots of detail that is not particularly fun to go through about how one withdraws it, that's actual steps to adoption, but none of that is of particular importance. The real change is that tiered approach, and that these SDSs are intended to function at a level that is wider geographically than what a local plan would do. And as I said, the closest analogy I can think is like a Part 1 local plan. And we kind of a strip down on Part 1 local plan, because if you take a Part 1 local plan now, you might be able to split it into two halves broadly. One half will be sort of generic development management policies, which might relate to landscape, ecology, biodiversity, heritage, etc., etc. All of them, strip them out, because that will go into national development management policies. And then the other half of a Part 1 local plan will be, here's your housing requirement, here's your distribution, here's your settlement strategy. That is what an SDS will become, but simply that for a larger area. As I said, with your Part 2 local plan, so your development plan for the specific area, coming forward with the meat on the bones to say, well, here's where those allocations will go. Hopefully, John, that's a high-level review of what these SDSs are going to be.
Thank you very much, Killian. Sorry, I'm just switching my camera back on. Again, whilst you were delivering that, there was a lot of questions, and I think what I've tried to do to help you out, and you can thank me later, is answer probably half wrongly. But no, and I see Stephanie as well has been helping out on that. So apologies again to everybody who hasn't had their question answered. Same things before, limitations of time and whatever, but we're doing our best to provide answers where we can, and no doubt Killian will be able to look through those now he's delivered his part. Thank you again. That was really interesting and illuminating, and as are many of the questions themselves. So if I could turn next, please, to Stephanie, moving on to quite different but equally important, or maybe more important topic, the reforms to the DCO NSIP process. Stephanie, I think you I know has been involved in a number of those cases, and I'm looking forward very much to get her take on whether or not these things that are being proposed are sensible and explaining the detail of them. So thanks very much, Stephanie. Could you lead on?
Thanks, John. My turn to tangle with the IT gremlins. We're going to start sharing my screen, and if people start shouting at me, then I'll see what I can do about it. But IT, not my forte, as anybody who knows me will attest. Right. So what does the Planning and Infrastructure Bill mean for NSIPs? It certainly had this as one of its core targets. And we can see that some of the, I think I've already found a gremlin. Oh, there we go. So the background to this is worth having a look at to see what they're trying to do before we have a look at what they've in fact achieved. So the background comes from the National Infrastructure Commission 2023 study on the national policy statements, the NPSs. This area of law, as everyone will know, absolutely rife with acronyms. So the NIC 2023 study on NPSs and the NSIP regime. And one of the quotes that I've pulled out for us there is about challenges. So, and timescales, because one of the core areas that the government is seeking to improve is speed. And they've got some pretty punchy targets for how many DCOs they want to approve by the end of this parliament, which would see a really significant ramping up of applications and approvals. So that the 2023 study said, well, look, initially the system worked all right. But since 2012, consenting times have increased by 65%, moving from 2.6 years to 4.2 years. And also they noted that the rate of judicial review had spiked in recent years to 58% from a long-term average of 10%. And they also said that the system had in part decelerated because the NPSs hadn't been updated since they were first issued and hadn't been supported by clear supplementary guidance. I think we can all, we've all felt that, or those working in that sector have felt, the absence of the NPSs really keeping up to date with the pace of change in technology. And it took particularly a really long time for them to get a water infrastructure NPS out. And it took a long time for EN3 to recognise that solar was a thing. So having some accelerated performance in policy would be of assistance. We've also had the Lord Banner review on challenges. So again, a real focus on the High Court and whether judicial reviews are seen as a hindrance to delivering infrastructure. And Lord Banner, Casey, gave a number of a number of recommendations, one of which was that there should be 2 opportunities to obtain permission for a challenge, just one in the High Court and one in the Court of Appeal. And another set out there was that the Civil Procedure Rules Committee should be invited to introduce some amendments to the Civil Procedure Rules, essentially to say that where there is a challenge to a DCO, that you shouldn't have to tangle with the written permission stage. You should go straight to a permission hearing on the basis that, well, those that seek to challenge DCOs are likely to be quite keen on actually seeing the thing through. So getting refused at a appropriate permission stage wasn't much of a deterrent, and that pretty much everybody was then orally renewing. Although I did see some stats to say, I think it was circa 70% of DCO JRs got permission. So whether permission is really a huge filter for loads on meritorious claims is potentially the background evidence isn't actually there for that. And so let's see what they've actually done. I mean, chapter 1 of the bill deals with NSIPs, and there's quite a lot in there. I've set out just some of the headlights. I'm not going to pick out all of these clauses, but just so that you can see that there's a run right from mandating policy review in clause 1 all the way through to kind of costs in clause 7. They've amended the JR procedure in clause 8, and then they've got some more technical amendments to dealing with transmission and energy infrastructure. There's also a whole load of stuff dealing with energy infrastructure in Scotland, which I'm not going to go anywhere near because I'm not qualified in Scotland. It's way off my patch. But I'm going to focus on, I've pulled out 4 points from this part of the bill that I think are worth us just dwelling on for a moment. So the first one is that policy point about that the National Infrastructure Commission recommended reviews to NPSs every 5 years. So we'll obviously, that sounds very similar in terms of a 5-year requirement to update a local plan. There's a 5-year requirement now to review NPSs. And as I said at the top of the section, I think obviously there were some uncertainty and delays from having policy that was well out of date with technology, and updates in that narrow scope could only be a good thing. But I have highlighted just on the page subsection 5C from the proposed clause in the bill, which is a get out of jail free card for the government. So there's a kind of, if it all proves too difficult, they've got themselves a little ticket out of the requirement for 5-year reviews. So I've obviously added in the highlighting and the underlining. So essentially that an amendment of an NPS that's required to be made by a certain time may be delayed beyond that time, only if and for so long as exceptional circumstances exist, which in the opinion of the Secretary of State makes the delay unavoidable. So the Secretary of State just has to reach a view that they think it's not avoidable. They're all too busy doing sorts of other things and couldn't possibly have the time to review the NPSs. Then there's a little get out of jail free card for them there. So query how often that will get used in practice. Then the second point that pulled out as being a particular interest is the power to disapply the requirement for development consent. Now, over this slide and the one across and the next one, I've pulled out the provisions that are on the right-hand side, just to show you, not because I'm expecting you to read that tiny text, but just to show you that it's like a really long, wordy provision. It's not particularly difficult to interpret, but it's just, there's a lot of words in it. And what it gets to, boiling it right down, is that a developer can apply in writing to the Secretary of State by a written request. So the term qualifying person is used, but a qualifying person includes somebody that's proposing to carry out the development. So essentially a developer can apply to the Secretary of State to opt out of the DCO regime if it, quote, considers it appropriate for an alternative consenting regime to apply. So you just have to get the Secretary of State to consider that that an alternative consenting regime would be appropriate. So alternative consenting regime here, clearly the most likely used one is going to be the Town and Country Planning Act. And the aim clearly here is to stop the clustering of solar farms, etc., at 49.995 megawatts coming forward. Sort of artificially throttling the generation capacity of infrastructure projects. And, there are two things really the government's trying to do to stop that. One is saying, well, if you've got in this scenario, a 55 meg scheme, that you could write to the Secretary of State and say, look, the TCPA is clearly appropriate for this. All of the land use planning considerations are not affected by my extra 5 megawatts. Thank you. Having an extra part of a field with some panels isn't really affecting anything very much. So why should I be having to go through all of the cost of the DCO regime? So that's helpful. This is just the next slide with the rest of that really wordy provision. And at the top on the right, obviously my views, it's, we're not really expecting a rush of people saying, I don't want to bring forward a DCO, but I would like to go into the Transport and Works Act order procedure or hybrid build procedure, please. The target is really, those kind of small to mid-sized energy projects that were artificially constrained really by the 50 megawatt threshold. There are two, and I did say there are two ways the government's trying to fix this. One is the opt-out in the bill, and the other is not in the bill, but is the Infrastructure Planning Onshore Wind and Solar Generation Order 2025. And when that takes effect, which will be the 31st of December, so back end of this year, onshore wind will be back into the DCO system, and onshore wind and solar will both have 100 meg threshold for using the NSIP regime. So you'll see, a doubling of size of projects being able to be consented under the TCPA scheme. So I'm afraid yet more work for planning authorities. So what are the factors that are going to go into choosing a regime then? Firstly, policy. If you're bringing forward a project under the town and country planning regime, you miss out on some of the strength of policy encouragement that's present in the NPSs. So you are not critical national priority infrastructure if you are below the NSIP threshold. You can make an argument to the planning authority and the inspector that you should be treated as if you were critical national priority infrastructure, but technically when one reads the definition of CNP you are not, so you lose out on that like a bit of extra bump. You don't have compulsory acquisition powers, so if you had a 100 meg or 200 meg scheme, well, the TCPA route is only any good to you if you've already got grid, obviously, and you've already got land, because you wouldn't have CPO powers. So, obviously the bigger the project, the more landowners you're going to have to tangle with, and the more that not getting land becomes the real throttle on your project. And query, how long will it take for the Secretary of State to respond to these requests? How many are they likely to get? And we don't know the timescale. So is this just introducing a bit of uncertainty and delay into your project? Because you're going to have to decide pretty early doors which route you're going down, given all of the pre-application and pre-submission consultation requirements for NSIP schemes. But happily, the test is just, is it appropriate for you to use the other route? You don't have to demonstrate it's the most appropriate or the only appropriate route. So the bar's pretty low for switching, but we're promised some guidance on what appropriate actually means. And point 3 from the bill that I've chosen to highlight is consultation. So this is one of the ways, or one of the levers that the government is trying to pull to make these things a little bit faster. So pulling some levers at the front end on consultation. There are some revisions to the pre-app consultation requirements and the contents of consultation statements to try and make those a little bit easier and concise and thematic is the term used in the guidance. So I'm not going to dwell on this given the time, because we're 2 minutes to 11 and I know people are going to have to get on, but there's plenty in the bill there. The other point that I pulled out about Cat 3 persons. So what they're doing is amending the requirement to consult those who you might have to pay compensation to, and replacing it with a requirement essentially just to tell them about it. And the kind of thinking face emoji there is because I'm not sure actually in reality that's a good idea. You're going to have to obviously identify all of those landowners that you might have to pay compensation to anyway, and that's a huge amount of the effort, and you're going to have to negotiate with them if you think you might have to compulsorily acquire their land because in order to meet the test for CPO. So I'm not sure in practice how much of a help that is, but to the government, thank you anyway. And finally, as I mentioned at the top of the slides, some, but not all of Lord Banner's proposals for changes to JR challenges have been taken up. One is about the totally without merit. So if you are certified, if your JR is certified as totally without merit, then you are not now going to be able to appeal to the Courts of Appeal. But I had a little look to see how many claims were really certified as totally without merit, because it's not something that happens particularly often. And apparently across 2022 to 2024, for which is the most recent period for which I could find data, and in the entirety of that year, only 5 of all JRs in all parts of the law were certified as totally without merit. So that feels like something that might not be particularly helpful. And the CPR is going to be amended to remove the paper stage. But query then the need to find a judge very quickly is going to be the real throttle on timing. So we just query how much difference that will make it in practice. So thank you very much. That brings me to the end of my slides.
Thank you very much, Stephanie. Again, very interesting. I noted that. I mean, I think the reform that would have made a big difference to that, and the thing that Charlie Banner was really going at or dealing with it, whether judicial review is a problem in NSIP cases, was the threshold, and they've not gone there with that. Whether the threshold should be more than arguable, which I think was
they thought about it. He thought about it, and the case is obviously not made out for that. I mean, I think that there are complications with having differential thresholds at different parts of the law. So
but I mean, if they really wanted to do it, that might have.
But yeah, they tinkered, and I think that's probably. Yeah. I think that's probably the headline for the whole of this section of the bill, actually. They've kind of tinkered at the front end and they've tinkered at the back end. But what they haven't done is go, right, let's just revisit this procedure from scratch. Are we really Are we really examining these projects in a way that is striking the right balance between public engagement, environmental protection, and getting things through? And could we do it better? And what they've done is sort of pull some little levers. What they haven't done is go, right, let's just do this differently.
And it was meant to be a fast, streamlined process as well. So in some ways, unless it had been botched from the start, you'd expect it to, there are tweaks, maybe. And I was just thinking, the one case I was involved that you talk about the artificiality of, schemes being 49.9 megawatts, or whatever. And that was precisely our case. So I suppose it makes sense to iron out those points. But yeah, in terms of vast improvements in timescales, it's difficult. You're saving a few weeks maybe by getting rid of the.
Yeah, you're just tinkering, exactly like getting rid of the paper permission stage. I mean, that's not, nobody I think was ever sort of crying about that to begin with and going, oh, this is the bit where there's all the delay, because it isn't. And actually, if your case is that important, you could have it certified as a significant planning court case and there are sort of streamlined timescales for that anyway.
But how you said that, I did think about it. Whereas, if what effect will that have? Because I mean, I think that puts it, and it's in an analogous position to when you have a Section 289.
Nice, yeah.
And you go straight to a hearing, push. And I was just thinking whether, by analogy with that, and I suppose it's especially given the significance of these cases, because they're going to relate by definition to NSIP, possible NSIPs. You would expect them to be more hardly fought, as it were. So whether the permission hearing will then become almost a full hearing as something.
I mean, it will should anyway.
I think that might result in actually fewer grants of permission, because really the judge on the papers is going, well, it seems to be arguable, but I've got an hour or less than an hour to read the papers and reach a decision on this. I can't kick it out now. But when they've heard half a day or a day legal submissions at an oral hearing, it may be they are more robust in their case management.
Yeah, although they don't have the benefit of the paper permission judge, which is usually try to kick it out on the papers. And then, so they've got a template, haven't they, if they want to refuse permission. Anyway, sorry, John, I noticed that we're over time.
We're way over time. I'm really sorry we can't answer any more questions. I've been trying to do it as we went along, and unfortunately Killian's had to leave, so we can't provide, I think, any of his wisdom on the topic he dealt with. I think I don't think there's anything else that I've seen that I could answer directly. But I want to thank firstly, everybody who's attended for coming and listening and for your participation in the questioning. It's really nice to know that the things we're talking about are things that inspire interest and that we can hopefully provide at least some guidance on. And of course, to all the speakers for the excellent talks. And I wish you all the best. But I'll draw things to a close at this point. Thanks very much. Bye-bye.